Imagine a world where the only response to war was just more war. For centuries, that was basically the status quo.
Right, there really wasn't a legal alternative.
Yeah. But today we're jumping into an exploration into the source material on a massive pivot. We are looking at the Nuremberg and Tokyo Tribunals between 1945 and 1948. It is literally the moment the world decided to trade the chaos of the battlefield for, well, the order of a courtroom.
And the goal here is to understand how these trials didn't just punish specific people.
Yeah.
They fundamentally rewrote the rules of war for everyone, establishing that individuals are accountable.
Okay, let's unpack this. It was a massive leap, right?
Oh, absolutely. Before 1945, international law really only dealt with how countries interacted. If a nation committed an atrocity, the state was considered guilty, which is kind of, it's like blaming a building for a fire.
It doesn't really catch the arsonist.
Exactly. Nuremberg changed that by saying actual human beings are accountable for what they do, even in the name of a government.
So starting with Nuremberg, things kicked off with the 1945 London Agreement. The Big Four powers led it, but the research points out that 19 other countries adhered to it.
They basically agreed to play by these new rules, which gave the whole 1945 to 1946 proceeding immense global weight.
And the scale was huge. They put 22 individuals and 7 Nazi organizations on trial. But that detail jumped out at me. Why put an organization like the Gestapo in the prisoner's dock?
That was actually a brilliant legal shortcut. By convicting an entire organization, they established that its very existence was criminal.
Making it easier to prosecute the individual members later.
Exactly. It made prosecuting thousands of lower-level members in subsequent trials much faster.
Wow, so building a foundation. Now, the notable absentee, obviously, was Adolf Hitler.
Right, due to his suicide.
But for the 22 guys who were there, a conviction wasn't a sure thing. 19 were found guilty, but 3 were actually acquitted.
Which is a vital detail. It showed the world these weren't just show trials. It proved the old, I was just following orders. Defense was no longer a valid shield.
Here's where it gets really interesting, though. While things were wrapping up in Europe, a totally different legal drama was happening in the Pacific.
Yes, the International Military Tribunal for the Far East. The Tokyo Tribunal.
And unlike Nuremberg, this wasn't an international treaty. It was a proclamation by General Douglas MacArthur.
And the jurisdiction was totally different. Nuremberg focused strictly on the war years, but Tokyo reached all the way back to the 1931 invasion of Manchuria.
That is nearly 15 years of conflict.
Yeah. They tried 28 defendants in total. That included 9 political leaders, 18 military figures, and interestingly, 1 scholar.
But wait, if the goal is absolute individual accountability, how does the source material explain the biggest name missing from that list? Emperor Hirohito just stayed on his throne.
It is easily one of the most debated points of the era. The decision to grant him immunity was heavily political. The Allies essentially feared that putting the emperor on trial would cause Japan to descend into an uncontrollable insurgency.
So they traded some justice for the stability needed to rebuild the nation.
Precisely. And it's worth noting that, unlike Nuremberg, all 25 defendants who lived to the end of the Tokyo trial were found guilty.
Okay, so with all these convictions across both tribunals, what exactly were the charges? The legal framework gives us 3 core crimes.
The first being crimes against peace, which is planning or waging an aggressive war.
To put that in perspective, that's like being arrested just for starting a bar brawl, regardless of how you actually swing your fists.
Great analogy. Then you have war crimes, which are violations of the customs of war, things like murder or plunder.
So that's the boxer using a lead pipe in the ring.
Right. And the third is crimes against humanity. Inhumane acts against civilians, like extermination or enslavement. It was the world finally saying, some acts are so horrific they are crimes against the entire human race.
If we connect this to the bigger picture, these definitions are the blueprint for everything we have now. The tribunals for Rwanda, Yugoslavia, and the Permanent International Criminal Court.
They also gave us the principle of complementarity.
Meaning national courts go first.
Yes. Your own country's courts lead the way, and international courts are just a backstop if the national system is unwilling or unable to act.
So to quickly summarize, we have 2 different foundations, a treaty and a proclamation, 3 core crimes, and a massive legacy of accountability.
It truly changed the world.
To wrap up our exploration, let's leave everyone with a provocative thought. We mentioned Nuremberg put organizations on trial, and Tokyo prosecuted a scholar for his ideas.
Right, Shumei Shikawa.
If ideas, institutions, and scholars can be guilty alongside generals, how does that change the way we view the responsibility of modern organizations today?
It definitely makes you wonder where we draw the line for thought leaders and influencers in the digital age.
Something to think about. Thanks for joining us on this exploration.
When the dust settled on the biggest war in human history, the world was left with this enormous question. What do you do with the people who lost? You know, the ones who caused it all. Well, the answer wasn't just about revenge. It was about trying something totally new, this radical idea of international justice.
I mean, think about it. Can you actually put a country's leader on trial for starting a war? It's a huge question, right? It's all about power and who's held accountable. And back then, with the world literally in ruins after World War II, this wasn't just some high-minded philosophical debate. No, this was a real, urgent problem that needed an answer, and fast.
You know, today, the idea of international justice feels, well, pretty normal. We hear about the International Criminal Court, the ICC, and we just kind of accept that leaders can be held responsible for terrible things. But it was not always like that. Not even close. This whole concept, the idea of global justice, it had to be built from the ground up.
So where did this wild idea even come from? Well, to figure that out, we have to go back to the end of World War II, to a world still smoldering. It was in that moment that the winners, the Allied powers, decided to do something no one had ever really done before, put the leaders of a sovereign country on trial for the crime of starting a war.
All right, so here's our game plan. We're going to see how this whole new kind of justice came to be. We'll look at the two big trials that set the stage, Nuremberg and Tokyo. We'll dig into the brand new crimes they actually defined. And finally, we'll connect the dots to see how it all leads to the world we have today.
Okay, first up, a new kind of justice. Picture this. The war is finally over. The Allies have won, but they've got a huge problem. The scale of the atrocities committed by Nazi Germany and Imperial Japan was just unimaginable. A simple military victory wasn't going to cut it. Something more was needed. A new kind of reckoning.
And you know what's interesting? This idea of putting war criminals on trial wasn't just some last-minute thing they whipped up in 1945. Nope. They were laying the groundwork for years. It started way back in 1942 with agreements like the St. James Declaration. Then came the London and Potsdam Agreements in 45. They were deliberately building a legal framework, step by step, for what they called organized justice. All right, let's talk about the Nuremberg Blueprint. This is the one most people have heard of. It all went down in Nuremberg, Germany. Here, the four main Allied powers, that's the US, the Soviet Union, the UK, and France, got together and created something called the International Military Tribunal. Their goal? To put the highest-ranking Nazi officials they could find on trial. This was the model, the one that would set the standard. Now, this is where things get really fascinating. We tend to lump Nuremberg and Tokyo together, but they were actually set up very differently. See, Nuremberg was born from an agreement between four nations. It was a truly international thing. But the Tokyo trial? That was established by a proclamation from one guy, U.S. General Douglas MacArthur. That tells you a lot about the different power dynamics at play in Europe versus the Pacific. So, what actually happened at Nuremberg? Well, the main trial went on for almost a full year. And the results were pretty clear-cut. Out of 22 of the top Nazi leaders on trial, 19 were found guilty. But here's something else that was a really big deal. The tribunal didn't just go after individuals. They declared entire groups like the SS and the Gestapo to be criminal organizations. That was a game changer. It meant entire parts of a government could be held accountable. Okay, now let's shift gears and head over to the other side of the world, to the Tokyo counterpart. This was the International Military Tribunal for the Far East. Basically, it was the Allies' effort to deal with Japanese war crimes, taking the new legal ideas from Nuremberg and trying to apply them in a totally different political and cultural setting. The trials in Tokyo actually went on even longer than Nuremberg, all the way from 1946 to 1948. And the result was, well, even more uniform. Every single defendant who made it through the whole trial was found guilty. But, and this is a huge but, look who's not on that list. Emperor Hirohito and the entire imperial family. They were never even charged. That was a purely political call made by the Allies who thought they needed the emperor to keep Japan stable after the war.
You know, as important as the verdicts were, you could argue that the most important thing to come out of these trials wasn't who was found guilty, but the words they used to do it. See, to prosecute these kinds of horrors, you first had to give them a name. They were literally creating a new vocabulary for global crime.
It all came down to three main categories laid out in the Nuremberg Charter. Now, war crimes, that was a concept people were already kind of familiar with. But the other two, crimes against peace and crimes against humanity, these were revolutionary. Crimes against peace meant that for the first time ever, the very act of planning and starting an aggressive war was in itself a crime you could be put on trial for. Think about that. And then you have this quote, which just nails the breakthrough idea behind crimes against humanity. Before this, what a government did to its own people inside its own borders was basically considered its own business. But this changed everything. It said that things like murder, extermination, and persecution of your own civilian population, that wasn't a domestic issue anymore. It was a crime against all of humanity, and the world could hold you accountable for it. So what about the lasting legacy? Well, the story definitely doesn't end when the trials wrapped up in the late 1940s. Far from it. The ideas and the principles that were forged in Nuremberg and Tokyo, they became the absolute foundation for all modern international criminal law. They're still shaping our world today. Okay, if you take away just one thing from all this, let it be this. These trials completely changed the game. They shattered the old idea that you could hide behind the concept of the state. For the first time, it was established that individuals, even presidents and generals, are personally responsible for their actions. The whole "I was just following orders" excuse, it was off the table. That principle, individual criminal responsibility, is the bedrock of everything that followed. And you can draw a straight line from then to now. The models they created in the 40s were dusted off and used again in the 1990s to create special tribunals for the conflicts in the former Yugoslavia and in Rwanda. All of that momentum eventually led to the big one, the creation of the Permanent International Criminal Court, or ICC, in 2002. The goal was to make the Justice of Nuremberg a permanent fixture in our world. But it's not a perfect story. Right from the start, these trials were hit with a heavy criticism that they were nothing more than victor's justice. I mean, only the losing side was ever put on trial, right? It's a critique that really sticks, and it leaves us with a tough question that we're still wrestling with today. Can international law ever be truly neutral, or is justice always, ultimately, decided by who has the most power?
I want you to close your eyes for a second. Unless you're driving, please don't do that.
Yeah, definitely keep your eyes on the road.
Right. But if you can, try to mentally inhabit the year 1945, specifically the autumn of 1945. Because, we always look back at this moment in history books as the big happy ending. Credits roll, the sailor kisses the nurse in Times Square, confetti falls, the bad guys are gone.
Which is, it's a beautiful narrative, but physically and morally, the world was basically an open wound.
Exactly. It's year zero. You look at cities like Berlin, Warsaw, Tokyo.
They aren't just damaged.
No.
They are moonscapes. I mean, there is no government, no police force, no functioning economy.
And amidst all this rubble, you have the Allied powers, the U.S., the U.K., the Soviet Union, and France. And they're standing there looking at each other, realizing they have a problem.
A massive problem.
A problem humanity has never actually solved before.
Yeah, it's the problem of the vacuum. Because you've defeated a regime that didn't just fight a war. They constructed an industrial assembly line of death. They committed atrocities that were so organized and so massive that there wasn't even a word for them yet in the dictionary.
And now you have the leadership of these regimes sitting in custody. You have Hermann Göring. You have the Japanese military cabinet. The guns are silent. And the big question hanging in the air is, what do we do with them?
And if you look at history, the standard operating procedure for the situation was incredibly simple.
You line them up against a wall and you shoot them.
Right. Or you exile them to a rock in the ocean like Napoleon.
And honestly, that is what a lot of people wanted. I was reading our source material for this deep dive, Foundations of International Justice, and it points out that Winston Churchill,
who we think of as this ultimate bastion of democracy.
Exactly. Even Churchill was initially pushing for summary executions. He basically said, look, these men are outlaws. We don't need a trial to know they're guilty. Just identify them and shoot them.
And it wasn't just Churchill. The Soviets, they wanted a trial, but in the Stalinist sense.
Show trial.
Yeah, a show trial. You read the verdict first, then you have the trial, then you shoot them. It's theater. It's not justice.
But then you have this push, largely from the Americans, specifically Secretary of War Henry Stimson and later Justice Robert Jackson, who say no.
They realize that if we just shoot them, we are no better than they are. We have to do something radical. We have to give them a fair trial.
A fair trial for the architects of the Holocaust. I mean, Think about the restraint that requires.
It's staggering.
And that decision is the seed of everything we are getting into today. Welcome to our deep dive into the foundations of international justice. We're looking at the two massive tribunals that basically created the modern world.
The International Military Tribunal in Nuremberg and the International Military Tribunal for the Far East in Tokyo.
The IMT and the IMTFE. The twin pillars of international law.
And I think we should be clear about our mission with this deep dive.
Yeah, go ahead.
This isn't just a history lesson about 1945. We were exploring a blueprint. We're looking at how a group of lawyers, judges, and generals essentially invented the concept of individual criminal responsibility out of thin air.
Building the plane while flying it?
Actually, it's more like they were building the plane while flying it through a hurricane. They had to invent the court, invent the procedures, and most controversially, define the crimes themselves.
Which is wild. So let's unpack the architecture of this thing. Because I think there's a common misconception that the war ended in May 1945, and then everyone just decided to have a trial in November. But the groundwork started way earlier, didn't it?
Oh, much earlier. You really have to go back to 1942.
To the St. James Declaration.
Exactly. And context here is key. Because 1942 is not a happy time for the Allies.
No, it's the darkest hour. The Nazis control continental Europe. The Japanese are expanding across the Pacific. The outcome of the war is very much in doubt.
Right. And yet, representatives from the exiled governments,
like Poland, Greece, Norway.
Yeah, they gather in London at St. James Palace with the US, the UK, the USSR, and China.
And they release this declaration condemning Germany's, quote, policy of aggression.
But it wasn't just a complaint letter. It was a promissory note. They explicitly stated that punishment through the channel of organized justice was a principal war aim.
Through the channel of organized justice. That is such a specific phrase.
It really is.
They didn't say vengeance. They didn't say retribution.
Right, because even while they were losing, they were committing to the idea of law. They were signaling that when this is over, we aren't going to just massacre the losers. We are going to process them. It set the intellectual stage for everything that followed.
So fast forward to August 1945. The war in Europe is over. Yeah. The Big Four meet in London to sign the birth certificate of the Nuremberg trials. The London Agreement.
Which is the legal foundation. And it's fascinating because it's a treaty. It's a contract between nations.
And it wasn't just the Big Four, was it? I was looking at the signatory list in the source, and it's surprisingly long.
It is. While the US, the UK, France, and the USSR were the architects, 19 other countries adhered to the agreement. We're talking places like Ethiopia, Honduras, New Zealand, Haiti.
Why does that matter? Like, why get Honduras involved in a trial in Germany?
Legitimacy. This was the crucial battle. The Germans were already claiming this was victor's justice.
That the winners were just punishing the losers because they won.
Exactly. By getting global buy-in, the Allies were trying to say, no, this isn't just America versus Germany. This is humanity versus these crimes.
So they established the IMT, but then they went into a practical nightmare. You have 4 countries with completely different legal systems trying to run one single court.
It was a recipe for disaster.
Yeah.
You have the Americans and British with their common law system, very adversarial, cross-examinations, strict rules of evidence.
Right.
Then you have the French with civil law, which is more inquisitorial, where the judge plays a bigger role in finding the truth. And then you have the Soviets.
Who just wanted to get to the sentencing phase?
Basically, yeah. The Soviet legal system at the time was, well, efficient, let's call it. They viewed the trial as a formality to demonstrate guilt that was already assumed.
So you have these 4 teams of prosecutors and judges constantly arguing over procedure.
Constantly. Can we cross-examine? Can the defendant speak? It is an absolute miracle they agreed on a rule book at all.
And the structure they finally landed on was 1 judge and 1 prosecution team from each of the 4 powers.
Which meant the bench had 4 voting judges. You needed a majority to convict.
Now, before we get into the actual courtroom drama of Nuremberg, let's pivot to the Pacific. Because Tokyo, the IMTFE, was set up very differently. Nuremberg was a treaty. Tokyo was, what, a memo?
Essentially, yes. It was a special proclamation.
By one man.
General Douglas MacArthur, the supreme commander for the Allied powers.
That feels like a massive distinction. In Europe, it's a committee. In Japan, it's a dictator. A benevolent one maybe, but still a single authority?
It totally reflects the nature of the occupation. In Germany, the country was carved up into 4 zones. But in Japan, it was almost entirely an American show. MacArthur was the law. So in January 1946, he issues this proclamation establishing the tribunal.
But he did bring in other judges. It wasn't just Americans sitting on the bench.
No, the coalition was actually broader than Nuremberg. MacArthur appointed judges from the countries that signed the Japanese surrender.
So the Big Four plus Australia, Canada, China, India, the Netherlands, the Philippines.
Yeah, a really wide geographic spread.
I want to touch on the Soviet involvement in Tokyo.
Yeah.
Because the timeline is a bit tricky based on our sources. The Potsdam Declaration in July 1945 called for stern justice, but the Soviets didn't sign it right away.
Because they weren't at war with Japan yet.
Right, they had a neutrality pact.
The Soviets didn't declare war on Japan until August 8th, 1945, literally between the Hiroshima and Nagasaki bombs.
A last-minute land grab.
Exactly, but once they declared war, they earned their seat at the table in Tokyo.
Okay, so we have our courts, we have our judges.
Yeah.
But now we come to the part that I think is the most intellectually difficult. The laws themselves.
Ah, the retroactivity problem.
Nullum crimen sine legis. No crime without law. It's a fundamental principle of justice.
It is.
You cannot arrest me today for wearing a red shirt if you only pass the law banning red shirts tomorrow.
Precisely. And in 1939 or 1941, there was no international penal code. There was no statute that said, if you invade Poland, you go to jail for 20 years.
So the Nazis and the Japanese argued quite legally that everything they did was authorized by their own sovereign states.
They did. And so how did the Allies get around this? Because if they failed here, the whole trial is a sham.
They had to be creative. They looked at existing treaties, right? Like the Kellogg-Briand Pact of 1928.
Yes, the pact that renounced war as an instrument of national policy. The Allies argued, look, you signed this treaty, you promised not to wage aggressive war, therefore when you did, you broke the law.
That feels like a bit of a stretch, though. Breaking a treaty usually means diplomatic sanctions, not hanging the foreign minister.
It was a stretch. That's why I say they were inventing the law. They took that treaty violation and elevated it into a personal criminal act.
Which brings us to the famous 3 core crimes of the Nuremberg Charter, the ones that Tokyo copied.
Yes, let's break these down, because these definitions basically run the world today.
First up, crimes against peace.
The prosecutors called this the supreme international crime. This is defined as planning, preparing, initiating, or waging a war of aggression.
Basically starting the fight.
Yeah, but think about the implications. Throughout history, kings and emperors started wars for land, for glory, for resources. It was just politics.
Now, suddenly, it's a crime.
It criminalizes the architects of conflict.
Then you have the second bucket, war crimes.
This was the safest legal ground. These were violations of the laws and customs of war. Things that had already been codified in the Geneva Conventions and the Hague Conventions.
Mistreatment of POWs, killing hostages, using poison gas, the soldiers' crimes.
Right. The Charter specifically mentions the wanton destruction of cities not justified by military necessity. This was a familiar territory for military lawyers.
But
then we get to the third bucket.
The one that changed everything. Crimes against humanity.
This was the revolution.
How exactly was it defined in the Charter?
It was defined as murder, extermination, enslavement, deportation, and other inhumane acts committed against any civilian population.
Any civilian population. That is the key phrase, isn't it?
It is the earthquake that shattered the concept of sovereignty.
How so?
Before 1945, international law stopped at the border. If the German government wanted to pass laws stripping German Jews of their citizenship, stealing their property, and putting them in camps.
Legally, that was Germany's internal business.
Exactly. The world could protest, but they had no legal standing to intervene.
Crimes against humanity said, we don't care about your borders.
It said there are certain acts that are so heinous, so universally repugnant, that they transcend national law. Even if your own laws say it's legal to exterminate a minority group, international law says it's a crime.
That is a massive leap. It basically says that human rights exist above the state.
It's the birth of modern human rights law. I mean, without this definition, you don't have the Genocide Convention. You don't have the Universal Declaration of Human Rights.
It all stems from this moment where the Allies said, we are going to prosecute you for what you did to your own people.
Yes.
So they have the charges. They have the framework. Let's go to Nuremberg.
Yeah.
November 1945, the Palace of Justice.
Which was one of the few buildings actually left standing in Nuremberg.
And the symbolism there was thick. Nuremberg was the holy city of Nazism. It was where the massive rallies happened.
Where the Nuremberg laws stripping Jews of their rights were passed.
So holding the trial, there was a deliberate exorcism.
Precisely. You take the spiritual home of the Reich, and you turn it into the deathbed of the ideology.
Describe the courtroom for us, because from what the sources describe, this wasn't a normal trial setting.
It was a technological marvel. For the first time ever, they used simultaneous translation.
Right. IBM provided the system.
Yeah, this complex system of microphones and headsets, you could switch a dial and hear the proceedings in English, French, Russian, or German in real time.
That seems so standard now at the UN, but in 1945, that was sci-fi stuff.
It was crucial. Without it, the trial would have taken 10 years. It allowed the trial to move at the speed of conversation.
And who's in the dock?
They indicted 22 senior German leaders, the major war criminals.
But the biggest fish was missing.
Hitler was dead, Goebbels was dead, Himmler was dead, all by suicide.
So the highest-ranking Nazi there was Hermann Göring.
The Reich Marshal. And Göring is such a fascinating study in this trial. When he arrived, he was a mess.
Yeah.
He was obese. He was addicted to paracodeine, which is a morphine derivative. He was literally carrying suitcases full of pills.
But he sobered up in prison.
He did. The army doctors weaned him off the drugs. He lost weight and his mind sharpened.
Which made him dangerous.
Very. By the time the trial started, he was formidable. He essentially became the captain of the defense team.
Wow.
He was charming, arrogant, and incredibly sharp. There were moments where he actually outmaneuvered the American prosecutor, Robert Jackson, while on the stand.
That is a terrifying thought.
Yeah.
That this monster could charm a courtroom.
It scared the Allies. They realized that giving these men a platform was a massive risk. Göring tried to turn the trial into a defense of Germany, arguing that they were just doing what any great power would do to protect its interests.
But the evidence was overwhelming. And it wasn't just witnesses. It was the documents.
That was the brilliance of the prosecution strategy. The Nazis were meticulous bureaucrats. They wrote everything down.
So the prosecutors just had to stack the memos on the table.
Exactly. Here's the order you signed to liquidate the ghetto. Here is the architectural drawing of the gas chamber you approved.
It was undeniable. There was another legal innovation at Nuremberg that the source material highlights. I find it fascinating and honestly a bit scary. The concept of criminal organizations.
Yes, this was the strategy to deal with the sheer scale of the terror.
Because you couldn't try every single SS officer individually. There were hundreds of thousands of them.
So you put the SS itself on trial.
Explain how that works.
The indictment asked the tribunal to declare groups like the SS, the Gestapo, and the leadership corps of the Nazi Party as criminal organizations.
What is the practical effect of doing that?
Well, if the court rules the SS is criminal, then in future trials for lower-ranking members, you don't have to prove the SS was bad.
You just prove the guy was a member.
Exactly. It shifts the burden of proof. It makes the cleanup operation much, much faster.
But isn't that basically guilt by association?
It is, and that's why it was so controversial.
Did the judges just rubber stamp it?
Actually, no. The tribunal was quite careful with this. They did declare the SS and Gestapo criminal, but they refused to declare the entire German cabinet or the general staff criminal.
Drawing a line.
Yes. They didn't want to create a precedent where just being a government minister or a general is automatically a crime.
So the trial ends in October 1946. What were the verdicts?
Of the 22 defendants, 12 were sentenced to death by hanging, 3 were sentenced to life in prison, 4 got terms between 10 and 20 years.
And going.
Death. But he cheated the hangman.
Right, the cyanide capsule.
Yeah, he managed to get a capsule. No one knows exactly how. Maybe from a guard he befriended and committed suicide the night before his execution.
But our source points out that the most important verdict wasn't the hangings. It was the acquittals.
Absolutely. 3 men were found not guilty.
Hjalmar Schacht, the banker, Franz von Papen, the diplomat, and Hans Fritzsche, the radio propaganda guy.
Yes.
Why is that so important? I imagine people were furious. The Soviets must have been apoplectic.
The Soviets wanted to appeal. They were absolutely furious. But legally, those acquittals saved the reputation of the tribunal.
Because it proved it wasn't rigged.
It proved that the judges were actually looking at the evidence. They looked at Schacht and said, he helped rearm Germany, yes, but he lost power before the war started. We can't prove he planned the aggressive war.
It proved this wasn't just a kangaroo court.
Exactly.
Let's move to Tokyo, the IMTFE. If Nuremberg was a tight, focused drama, Tokyo feels like a sprawling epic.
It was much longer. Nuremberg took less than a year. Tokyo took 2.5 years, May 1946 to November 1948.
And the scope of what they were looking at was massive.
Right. Nuremberg focused mostly on 1939 to 1945. but the Tokyo Tribunal had jurisdiction going back to the invasion of Manchuria in 1931.
They were litigating 14 years of history across the entire Asia-Pacific region.
That was a massive undertaking.
The defendant list was also different. In Nuremberg, you had this mix of party hacks, military guys, and bureaucrats, but Tokyo was very heavy on the military.
28 defendants initially, mostly generals and admirals. It reflected the military junta that essentially ran Japan.
With Hideki Tojo as the central figure.
Tojo, the prime minister and war minister, yes.
But we have to talk about the person who wasn't there. The emperor.
The enormous elephant in the room.
Emperor Hirohito. He wasn't dead. He was sitting in his palace right there in Tokyo.
He wasn't indicted. He wasn't even called as a witness.
Okay, play devil's advocate here. We just spent all this time talking about individual criminal responsibility. How head of state immunity is dead. How on earth do you justify letting the actual head of state off the hook?
Legally, you can't. It's pure hypocrisy.
So why do it?
Politically, MacArthur and the Truman administration made a cold calculation. They believed that the emperor was the absolute keystone of Japanese society.
They needed him.
They feared that if they arrested him or hanged him, Japan would descend into chaos or communism or a permanent guerrilla insurgency.
So they needed him to legitimize the American occupation.
Exactly. They used him, they kept him on the throne as a figurehead to tell the Japanese people, cooperate with the Americans.
But to do that, they had to pretend he was an innocent pacifist.
Yeah, the narrative was that he was manipulated by his bad generals.
That must have made the trial incredibly awkward for the defendants.
It was surreal. You had Tojo, who was fiercely loyal to the emperor, trying to defend himself without implicating the emperor.
Even though everyone in the room knew the emperor signed off on the war.
Right. The prosecution and the defense were essentially dancing around this silent figure the whole time.
There's another aspect of Tokyo that we need to dig into from the source material. The dissent. Because in Nuremberg, the judges mostly agreed. But in Tokyo, it was a brawl.
It was a 7-4 split on some of the verdicts. But the most famous dissent came from the judge from India.
Radhabinod Pal.
Judge Pal.
This is a name that really doesn't get taught enough in Western history classes.
He wrote a massive dissent, thousands of pages long, arguing that the entire tribunal was illegitimate.
What was his argument? Was he saying Japan didn't commit these crimes?
Not exactly. He acknowledged the atrocities happened, but he argued that the crimes against peace charge was ex post facto law, retroactive justice.
Which was the big fear.
And more importantly, he called out the colonialism of the Allies.
Wow.
He basically asked, who are you, the British, the Americans, the Dutch, to lecture Asia on aggression? You've been colonizing these countries for centuries?
He called it victor's justice right to their faces.
He viewed the trial as the white colonial powers punishing an Asian power for daring to challenge their dominance in the region.
That is a stinging critique.
It made him a hero to Japanese nationalists later on. But at the time, it was a scathing critique of the moral high ground the Allies were trying to claim.
What was the final outcome in Tokyo?
7 death sentences, including Tojo. 16 life sentences, no acquittals.
So a clean sweep for the prosecution.
Yes. But the legacy is much messier than Nuremberg because of the emperor issue and the Pal dissent. It felt less like pure justice and more like a political cleanup operation.
Now, a lot of people think the story ends there. The gavels bang, the hangings happen, and everyone goes home. But the source material makes it clear that the cleanup operation was actually much bigger.
Massive. Nuremberg and Tokyo were just the tip of the iceberg. We call them the subsequent proceedings.
Like in Germany, the Americans held 12 more trials in Nuremberg.
The subsequent Nuremberg trials, these are fascinating because they targeted specific sectors of society, not just the top politicians.
Like the doctor's trial.
Dealing with the human experimentation and the euthanasia program in the camps.
And that trial gave us the Nuremberg Code, right? For medical ethics?
Yes. The concept of informed consent comes directly from this trial.
Then you had the judge's trial.
Prosecuting the Nazi judges who legally enforced the terror state.
And the industrialist trials?
Krupp, I.G. Farben. Prosecuting the businessmen who built the war machine and used slave labor.
And perhaps the most intense one mentioned in the outline. The Einsatzgruppen trial.
The trial of the mobile killing squads. The prosecutor there was a 27-year-old American named Ben Ferencz.
27 years old. That is wild.
He was a legend. He actually just passed away recently. He landed the job because he literally found the reports.
What reports?
The Einsatzgruppen commanders filed daily memos. Shot 3,000 Jews in this village. shot 1,000 in this village.
Just treating it like accounting.
Exactly. Friends totaled them up. It was over 1 million murders. He went to his boss and said, we have to try these guys.
And his boss said no.
His boss said, we don't have the budget or the staff for another trial. So Friends said, I'll do it myself. And he went in and convicted 22 leaders of the death squads.
Incredible. And this brings up a concept from the text called complementarity. It's a heavy legal term, but explain it simply for us.
It's the relationship between international and national courts.
Okay.
The big tribunals, the IMT and IMTFE, handle the big fish, the leadership. The national courts or military zone courts handle the small fish.
So it's a tiered system.
Exactly. And that is how international law works today. The International Criminal Court, the ICC, is a court of last resort. It only steps in when the national legal system is unable or unwilling to prosecute.
It's not meant to replace local courts. It's meant to backstop them.
Precisely.
Let's move to the legacy section. Because we have an outline here from the source of 8 core areas where these tribunals basically built the world we live in. I want to go through these because this is the real so what of the deep dive. This is why we care today.
Let's do it.
Number 1, individual criminal responsibility. We've hammered this, but let's drive it home.
It is the absolute death of the act of state doctrine.
Meaning what?
Before 1945, if you burned a village down as a soldier, the argument was Germany did it. After 1945, the argument is Hans did it.
You cannot hide behind the flag.
Right. I was just following orders doesn't work anymore. It might reduce your sentence, but it doesn't remove your guilt. Moral agency is non-negotiable.
Number 2, due process, even for monsters.
This is crucial. If we had just shot Going, he becomes a martyr. By giving him a lawyer, by letting him cross-examine witnesses, by letting him speak.
We demonstrated the superiority of the rule of law.
Exactly. It showed that democracy isn't afraid of the truth.
Number 3, universal jurisdiction.
This is the idea that some crimes are enemies of all mankind.
Like piracy originally.
Yes, and now genocide. Therefore, any court anywhere can prosecute them. We saw this with Augusto Pinochet being arrested in London. We see it with Syrian torturers being put on trial in Germany today. The borders don't protect you from these specific crimes.
Number 4, ad hoc tribunals.
The direct children of Nuremberg.
How so?
When the world saw the genocide in Rwanda in 1994 and the ethnic cleansing in Yugoslavia, the UN didn't have to start from scratch. They pulled the Nuremberg blueprints off the shelf.
The ICTR for Rwanda and the ICTY for Yugoslavia.
They were structured almost exactly like Nuremberg.
Number 5, the ICC.
The permanent court. See, the dream of the Nuremberg prosecutors was that they wouldn't have to set up a brand new ad hoc court every single time a genocide happened.
They wanted a permanent building with permanent judges.
And that finally happened in 1998 with the Rome Statute. The ICC opened its doors in 2002.
Number 6, the lexicon.
The words we use: crimes against humanity, war crimes,
Genocide.
which wasn't technically in the Nuremberg Charter, but was coined by Raphael Lemkin during that exact same time period. These terms define how we see the news today.
Right. When we see a bombed hospital, we don't just say, oh, that's tragic. We say, that's a war crime.
That shift in language is incredibly powerful.
Number 7, command responsibility.
This is the one that scares generals.
Why?
It says a commander is responsible for the crimes of his subordinates if he knew or should have known and failed to prevent them.
So you can't just play golf while your troops burn villages.
Ignorance is not a defense if it's willful ignorance. You are in charge, you are responsible.
And finally, number 8, judicial innovation. Things like joint criminal enterprise.
I call this the RICO of war crimes.
Like prosecuting the mafia.
Exactly. It allows you to prosecute the guy sitting at the desk. You don't have to prove Adolf Eichmann physically turned the gas valve. You prove he organized the trains.
He was part of the enterprise.
It allows us to reach the white-collar criminals of war.
It's an incredible list. It's basically the operating system of global justice.
It really is.
But, and here's where I have to play the skeptic again, based on where we are today.
Go for it.
We look at the world right now. We see atrocities in real time on social media. We see leaders who seem to act with total impunity. We see powerful nations, including the US, Russia, China, who haven't even joined the ICC.
You're completely right.
So is this system actually working? Or was Nuremberg just a one-off moment because the Allies had total unconditional control?
That is the hard truth of international law. Nuremberg and Tokyo were totally unique because the defendants were already in handcuffs.
The Allies had won unconditionally.
Right. Today, we don't usually have that. We have messy, ongoing conflicts where the dictator is still in power. And the ICC has no police force. It can't just send SEAL Team 6 to arrest a warlord.
So the law exists, but the enforcement is weak.
The enforcement is political. But you shouldn't underestimate the power of the norm.
What do you mean by the norm?
Before 1945, a dictator killing his own people was just business as usual. It was sovereign privilege. Today, doing that creates a pariah status.
It changes how the world treats you?
Think about it. Vladimir Putin has an arrest warrant from the ICC. He can't travel to South Africa or Brazil without risking arrest. That narrows his world. It strips his legitimacy on the global stage.
It's not perfect justice, but it's not nothing.
It's a long game. The Nuremberg prosecutor, Robert Jackson, said that the trial was one of the most significant tributes that power has ever paid to reason.
Power paying tribute to reason.
Exactly. Usually power does whatever it wants. But in 1945, power paused and submitted itself to the rules of reason and law. We are still just trying to live up to that standard.
It feels like the legacy of Nuremberg isn't a statue that you visit. It's more like a garden you have to keep watering. Or maybe a fence you have to keep mending.
That's a beautiful way to put it. The plane they built in 1945 is still flying. But it requires constant maintenance, and sometimes the engines sputter.
But the alternative?
The alternative is going back to a world where might makes right, and that is unthinkable.
Well, this has been a heavy but absolutely necessary deep dive into the foundations of international justice. If you want to see how these definitions live on today, I encourage you to look up the Rome Statute.
Yeah, it's basically the modern operating manual for international justice.
And you will see the fingerprints of 1945 all over it. It's wild to read.
Absolutely. It's all right there in the text.
Thanks for diving deep with us today.
My pleasure.
And to you, listening at home or in the car, consider this. These tribunals were set up by united global powers after a catastrophe. In our increasingly fractured world today, does the legacy of Nuremberg hold up on its own, or do we need to actively fight to maintain these standards of truth and accountability? Keep asking the hard questions. See you next time.
Welcome to the debate. Today we are looking at the immediate aftermath of World War II. It is 1945, the world is in absolute ruins, and the victorious Allied powers are facing a massive problem. They have captured the men responsible for, well, the most efficient machinery of death in human history. The architects of the Holocaust, the rape of Nanking. But they had absolutely no established international law to judge them with.
Right. And summary execution was, it was the easy path. I mean, Winston Churchill actually suggested it. He wanted to just take the top Axis leaders out and shoot them. It would have been quick. It would have been vengeance.
Exactly. But ultimately they chose a harder road. They decided to build a courtroom. And that brings us to the central question we're debating today, drawn directly from the historical source material surrounding the International Military Tribunals at Nuremberg and Tokyo. Did these tribunals represent a triumphant establishment of universal justice and individual accountability, or were they fundamentally compromised by the structural reality of victor's justice, creating a flawed foundation for international law? I am representing the view that these tribunals were a revolutionary, necessary legal innovation that shattered state sovereignty and codified crimes against humanity.
And I will be taking the opposing stance. I argue that while the trials were, obviously historically significant, they were inherently limited by their geopolitical origins. It was selective prosecution, leaving a legacy that is much more complex and troubled than a simple victory for the rule of law.
So to lay out my position right off the bat, Nuremberg and Tokyo were the foundational moments that moved the modern world from chaos to order. Let's look at the bedrock here, the 1945 London Agreement and the Nuremberg Charter. This wasn't just the Big Four, the US, UK, France, and the USSR making up rules on a napkin. This was a massive international consensus. 19 other nations, from Ethiopia to New Zealand, adhered to the London Agreement. Before this moment, state sovereignty shielded leaders. If a head of state murdered his own people, that was internal affairs. These tribunals shattered that shield by indicting high-level figures like Hermann Goering, proving that status offers no immunity.
I hear the ambition in that, but we have to look at the execution. And the execution challenges the legitimacy of the entire project. I argue these were not true international courts, but instruments of the occupying powers. You cite the London Agreement, but look at the Pacific. The International Military Tribunal for the Far East, the Tokyo trial, was created solely by a special proclamation from U.S. General Douglas MacArthur. Furthermore, the selective nature of the justice is glaring. While German leaders were hanged, Emperor Hirohito was not even indicted. He retained his throne due to pure political expediency. That proved the tribunals were shaped by power dynamics, not blind justice.
Well, let's dive right into that legitimacy question, because I think framing it purely as a military fiat ignores the meticulous legal frameworks that were built. The intent didn't just spring up in 1945. The St. James Declaration of 1942 signaled this intent years in advance. And crucially, they adhered to due process. They utilized defense counsel. They relied overwhelmingly on documentation rather than coercion. At Nuremberg, 3 defendants were actually found not guilty: Hallmarschacht, Franz von Papen, and Hans Fritzsche. You do not get acquittals in a kangaroo court.
Acquitting 3 people doesn't validate the process if the foundational law is flawed from the start. The issue isn't whether they read documents. The issue is ex post facto lawmaking. The law was created after the fact by the victors. And I want to push back on the Tokyo structure. Unlike the London Agreement, which was at least a treaty, the Tokyo Charter was literally annexed to a MacArthur proclamation. MacArthur appointed the judges from the surrendering signatories. The Soviet Union didn't even sign the Potsdam Declaration until the very end. When you strip away the robes, Tokyo looks less like a court and more like a military administrative action.
It was authorized by the surrender terms, though. Japan agreed to those terms. And even if you want to criticize the structural setup in Tokyo, the definitions of the crimes themselves were a massive breakthrough. The specific creation of crimes against humanity, extermination, enslavement, deportation. That introduced the concept that a government's treatment of its own civilian population is a matter of international concern. And we also have to talk about the inclusion of criminal organizations, the SS, the Gestapo. This allowed for systemic accountability, not just individual punishment.
Systemic accountability through legal concept that was entirely alien to the defendants. Let's talk about the conspiracy charge. That is the perfect example of the legal gymnastics the Allies performed. Conspiracy was an Anglo-American common law concept. A German lawyer in 1945 would look at a conspiracy charge and ask, where's the statute for this? The Allies retrofitted a foreign legal theory specifically to widen the net. They needed a way to convict the bureaucrats who signed the papers but didn't pull the triggers.
But it wasn't a trick. It was a necessity of scale. How else do you prosecute a massive bureaucracy? The Nazi state was a criminal enterprise. The conspiracy charge allowed the tribunal to pierce the corporate veil of the state. It recognized that modern industrial terror requires a network. That isn't legal gymnastics. That is legal innovation catching up to industrial slaughter.
Innovation is one word for it. But let's look at another supposed innovation: crimes against peace, waging aggressive war. This is where the victor's justice argument really crystallizes. This was a completely new legal concept applied retroactively, in Japan's case, all the way back to the 1931 invasion of Manchuria. And it brings up the clean hands doctrine. In a court of equity, the accuser must have clean hands. At Nuremberg, you had the Soviet Union sitting in judgment of waging aggressive war.
Because they were a victorious power that had been invaded.
Yes, but look at the timeline. The Soviets invaded Poland in 1939 in direct coordination with the Nazis under the Molotov-Ribbentrop Pact. They invaded Finland. They annexed the Baltics. How can a Soviet judge sit there and sentence Joachim von Ribbentrop for waging aggressive war when the Soviet government did the exact same thing, literally in partnership with the defendant? It renders the moral authority of that specific charge into a total farce.
It makes it a paradox, absolutely. I concede the hypocrisy of the Soviet position, but a paradox is not a farce. The presence of a hypocritical judge doesn't make the defendant innocent of the crime. Ribbentrop did help plan an aggressive war. Stalin's guilt doesn't absolve the Nazis. And interestingly, the tribunal actually grappled with this. They allow the tu quoque argument, the you did it too defense, in certain specific instances.
Only when they were forced to. But they allowed it. Admiral Donitz was charged with unrestricted submarine warfare, sinking merchant ships without warning. His lawyer wanted to prove the Americans did the exact same thing in the Pacific. And the tribunal allowed an interrogatory from U.S. Admiral Chester Nimitz to be entered into evidence. Nimitz admitted that yes, the U.S. Navy engaged in unrestricted submarine warfare from day one. And because of that, the tribunal did not sentence Donitz for that specific crime. That proves the tribunal was capable of recognizing the hypocrisy and adjusting the sentence based on evidence.
They quietly factored it in, sure. They didn't sentence Donitz for it, but they certainly didn't put Nimitz on trial either. And regarding crimes against peace, you frame this as a breakthrough. I view it as the victors criminalizing the politics of the losers based on the Kellogg-Briand Pact of 1928. That was an aspirational piece of paper with no enforcement mechanism. To turn a diplomatic promise into a capital offense in 1945 is the definition of retroactive law, nolum cremens sine lege, no crime without law.
But isn't that how common law has to evolve? Sometimes the moral outrage is so severe that the law simply has to catch up. The militarists in Germany and Japan didn't just break a promise, they shattered the world. The tribunal essentially ruled that you cannot hide behind the technicality that the penalty wasn't written down in a specific code when you launched the panzers. The spirit of international treaties implied that aggressive war was illegal.
Relying on the spirit of the law is incredibly dangerous when the penalty is the gallows. And this danger was highlighted most famously in Tokyo. We have to talk about Justice Radhabinod Pal, the Indian judge on the Tokyo Tribunal. He wrote a massive 1,200-page dissent arguing the entire tribunal was illegitimate. He looked at the crimes against peace charge and saw it as Western colonial powers criminalizing any challenge to their dominance. He argued you cannot isolate Japanese aggression from centuries of Western imperialism in Asia.
Justice Pal's dissent is a vital historical document, but it was an outlier. And honestly, framing Japan purely as a victim reacting to Western imperialism distorts the reality of what they were doing to their Asian neighbors. The judges from China and the Philippines voted to convict. The Philippines endured the rape of Manila, the Bataan Death March. These were not abstract colonial grievances to them. This was butchery. For all its structural flaws, the Tokyo Tribunal gave a voice to those victims in a way that just executing Tojo in a courtyard never would have.
It gave a voice to some victims, yes, but it explicitly silenced others. The Tokyo Tribunal completely ignored the victims of the atomic bombs and the firebombing campaigns. If the indiscriminate killing of civilians is a crime against humanity, how do you prosecute the rape of Nanking but completely ignore the firebombing of Tokyo? Operation Meeting House killed 100,000 civilians in a single night. U.S. General Curtis LeMay famously said that if the U.S. had lost the war, he would have been tried as a war criminal. He knew the law didn't apply to him simply because he was on the winning side.
That is definitely the hardest reality to defend here. The selectivity is stark. I won't pretend it's fair that LeMay wasn't tried, but does the immunity of the victor negate the guilt of the vanquished? That is the intellectual trap of the victor's justice argument. It suggests that because we couldn't try everyone, we shouldn't have tried anyone. Holding Tojo and Goring accountable was a net gain for humanity. The precedent established that targeting civilians is a crime. It took decades for that standard to mature, but the vocabulary, the actual legal blueprint, started right there.
But let's look at the legacy of that blueprint. You claim these tribunals were the origin point for human rights. I see them as the blueprint for a very specific type of international court, one that primarily serves the geopolitical interests of its founders.
The direct line from 1945 to today is undeniable. Because of the Nuremberg principles, we eventually got the tribunals for Yugoslavia and Rwanda in the 1990s. Those courts prosecuted genocide, regardless of it being an internal conflict. And that led directly to the Rome Statute of 1998, which created the International Criminal Court. If you read the Rome Statute, the definitions of crimes, murder, extermination, enslavement, are nearly verbatim from the 1945 London Agreement. Without 1945, there is no ICC.
There is an ICC, but look at who participates. The United States is not a member, Russia withdrew, China never joined. The persistent legacy of Nuremberg is that the great powers, the ones who created the precedents, exempt themselves from it. The ICC has been heavily criticized for focusing almost exclusively on leaders from weaker nations while ignoring crimes committed by Western powers. That is the direct descendant of the Tokyo formula, justice for them, but never for us.
Evolution of the law itself. The ICC operates on the principle of complementarity. It only steps in when national courts cannot or will not do the job. That entire concept is a reaction against the imposition of a MacArthur-style court. It shows we learned from the criticisms of Tokyo. We are trying to build a system where national justice is the default. And frankly, the fact that we even have a legal vocabulary to criticize the US or Russia for war crimes is because of Nuremberg. Before 1945, there was no standard to hold them to. Now, even if they evade the jurisdiction of the court, they cannot evade the label.
They seem to evade the label just fine when it suits their interests. But I want to address this psychological shift you are implying. Do you really believe 1945 fundamentally changed how state leaders operate?
I do. Before 1945, a tyrant's retirement plan was a comfortable villa in a neutral country. Now a dictator knows there is a chance, however slim, that a warrant awaits them in The Hague. The impunity gap has not closed completely, but it has shrunk. We moved from a world where I am the state was an absolute defense to a world where I was just following orders is recognized as an admission of guilt. That is a massive leap in human consciousness.
It is a leap in rhetoric, but I worry that by canonizing these tribunals, we whitewash the history. We tell ourselves a fairy tale that justice neatly defeated evil in a wood-paneled courtroom. It obscures the fact that the Tokyo trial dragged on until 1948. 2 defendants died during the trial, 1 had a psychiatric breakdown. To many observers in Japan, it didn't look like universal justice, it looked like a prolonged ritual humiliation. And when justice looks like humiliation, it breeds resentment, not lasting reconciliation.
And yet look at the geopolitical result. Germany and Japan are today 2 of the most peaceful, law-abiding nations on Earth. The tribunals, for all their messiness, forced a confrontation with the past. The evidence was aired publicly, the films of the concentration camps were shown, the captured documents were read into the historical record. If the Allies had just summarily executed the leaders and burned the files, denialism would be rampant today. The evidentiary record is unassailable specifically because of the adversarial legal process.
I will grant you the value of the evidentiary record. The meticulous archiving of the horror was perhaps the only truly pure success of the tribunals. They didn't just hang people, they documented the abyss. But we must remain vigilant about the precedent itself. Nuremberg established that international law can override national sovereignty. That is good for human rights on paper, but it is incredibly dangerous when used as a pretext for military intervention by powerful states against weaker ones under the guise of international law.
That tension is exactly what defines the modern international system. But I would argue that I would much rather live in a world struggling imperfectly to apply the Nuremberg principles than a world that never invented them at all. The alternative in 1945 was a cycle of pure vengeance that might never have ended. Nuremberg broke that cycle. It replaced the firing squad with the gavel.
It replaced the firing squad with a gavel held by the nation with the biggest army. That is a step, perhaps. But let's not call it universal justice. Let's call it managed retribution.
I can accept managed retribution as a starting point. It is certainly better than unmanaged chaos. And that really brings us to the synthesis of this debate. When we look back at 1945, at those judges sitting in the rubble of a destroyed continent, we see the moment humanity decided that brute power wasn't enough. They needed to at least attempt to establish a framework of right and wrong.
A noble attempt, but one deeply marred by the reality of who was paying for the judges' robes. We agree that 1945 was the foundational moment, but it was a chaotic, explosive birth, creating an international legal universe that is still expanding, still cooling, and still highly unequal. Whether that birth was a moment of moral clarity or a complex compromise between justice and power is something we are literally still litigating today.
We are indeed. And as we look at global conflicts today and we hear terms like war crimes and crimes against humanity debated in the news, we have to remember where those concepts came from. They came from a massive legal gamble in 1945.
A gamble that paid off for some and left others wondering if the house always wins.
Thank you for joining us for this discussion. We hope this debate has illuminated the complex, messy, and absolutely vital origins of the laws that attempt to govern our world and encourages you to look deeper into the source material.
Keep questioning the verdict.